represented in a preliminary injunction case as it related to voting machines, Carrie Lake down in Arizona. And she happened to be a candidate at the time, so she was a plaintiff and was willing to and interested in being a plaintiff to challenge whether voting machines violate individuals' constitutional rights because they cannot be counted on to provide an accurate vote count. And of course, the machine companies greatly dispute that. The governments that hired these machine companies to count the vote greatly dispute that. But there are a lot of voters who don't have confidence in this system. So in representing Carrie Lake, that case became quite contentious. The court dismissed it after our complaint was filed. The Ninth Circuit affirmed the dismissal. We are preparing a petition to the Supreme Court to see whether they will hear the case. The reason for the dismissal was based on one legal theory in principle, and that is called standing, whether there was a concrete injury to these two candidates who were the plaintiffs in the case. And ultimately, the court determined that whether or not the vote count was reliable or challenging the reliability of the vote count was speculative and conjectural, and it wasn't concrete enough, and therefore the case could not go forward. We disagree with that. We continue to disagree with that, but the Ninth Circuit affirmed it. That's another interesting case. I represent Brian Lipschultz in the Otto Bremer Trust case, which is one of the biggest cases in the state of Minnesota right now. I don't know whether that's, we went up on appeal, and he was removed as a trustee of the Otto Bremer Trust by a district court judge in Ramsey County. We appealed it to the Court of Appeals, lost. They affirmed the removal. We appealed it to the Supreme Court. The Supreme Court agreed to hear the case, and it was heard, and recently ruled to affirm his removal. So that case has been resolved. It's a difficult standard. It's an abuse of discretion standard that the Court of Appeals and Supreme Court applied. And so they just acquiesced to the district court conclusions in that regard. But that's a very interesting case and a big case. The other set of cases that we've become very involved with are Lanham Act cases, theft of trade dress or trademark, one company against another or an individual. And we have an interesting case involving a company that sells cigars in a tube with humidification that keeps the cigar humidified for up to a year and beyond even in the tube. And so you don't have dried out cigars, and they sell them to golf courses, which has quite a clientele for this product and has for many years. What our complaint in that case alleges is that when this company was sold, one of the potential buyers who ultimately did not get the bid to purchase the company took all of the information provided to them on due diligence, which they had signed a non-disclosure agreement, took all that information, went across the street and started up their own single tube cigar humidification sales company. And so claims have been brought, and that is in litigation now.